Oh, we're live. Welcome.
Welcome.
To the Shapiro Law Firm presents a Facebook and YouTube Q&A discussion on I-751 petitions to remove conditions on residency. I am Attorney Amanda Schaefer. Joining me today is my co-host Aaron Shapiro, my brother-in-law and award-nominated father of two. Oh, I'm sorry, I forgot about Miss Goldie, the pups. Anyways, thank you for joining us today. While we wait for for more people to join in, we'll do our little introduction and required disclaimer. So Aaron and I have been practicing law for how long? How long you've been long?
I started in 2008.
I started in 2012.
Yeah.
We do immigration, family, some criminal defense. And what we say here today, here's our disclaimer, does not form an attorney-client relationship. We're in the nature of giving general legal advice. However, we are available for hire, and you can contact us at the phone number or email scrolling across the screen, and we'll be more than happy to help you.
If we can.
What's that?
If we can. Otherwise, right. We'll tell you the truth.
We're going to be honest with you. We're not going to take your money unless we really think we can help you. So we'll wait just a couple more seconds here. If you saw any of our other lives this week on notable approvals, we talked a lot about I-751s in anticipation of this live tonight. So with that in mind, it looks like we have all 5 people ready to go. No, I'm sure more people will come, but we should get started. I think this is a good time.
Well, people watch them recorded.
So, don't forget. Oh, we got some comments that we are answering your questions live today. So we did get a few questions in advance, but do not be shy. You can send us on the comments or chat section if you have any questions while we go along. If you want to ask a question anonymously, we have our emails open, so you can shoot us an email and we'll be happy to answer. And if we can't get to your question, we will definitely be in touch after the live event today. So with that in mind, the first question or first topic we're going to talk about today is a conditional versus a permanent resident. So what is a conditional resident and how is it different than a permanent resident? So if you marry a U.S. citizen or permanent resident and you're married for less than 2 years at the time of either the adjustment of status interview or if you did consular processing at the time you enter the U.S., then instead of getting a 10-year green card, you get a green card that's valid for 2 years. And in the 90-day period, well, we'll talk about when you have to file in a second, but essentially in the 90-day period before your 2-year green card expires, you have to file a Form I-751 petition to remove conditions on residency. And the reason that this exists is Congress put this in the law in order to prevent sham marriages or people who are only marrying to get an immigration benefit. So when you first get married, you are not going to have as much marriage evidence because if you're coming from abroad, you don't even live together. And if you're in the U.S., you might not have legal status and a social security number, so you might not have all that joint evidence yet. So the standard is a little lower. But 2 years later, you should have a lot more evidence to be able to prove that you entered into your marriage in good faith. So that's why it exists. And it also applies to children of, if they're stepchildren of U.S. citizen or permanent residents as well. And they could be listed as derivatives on their parents' application, or a step-parent can file directly for a child. So essentially, when you're a conditional resident, you have all the same rights as a permanent resident. You can work without special work authorization. You can travel abroad and re-enter the country. And the time that you are a conditional resident counts towards the time you need as a permanent resident to naturalize. Really the only difference is the time period that it's valid. And after the 10 years, you do not have to then apply it for another petition to remove conditions. You just renew your green card. So when do I file the I-751? I mentioned earlier that the general rule is, and this is for joint filing, so you and your spouse, you're still married, still living together, in the 90-day period before your green card expires, or the 2-year anniversary of having your green card, you have to file the petition. However, at any time, if you are no longer with your spouse, and this could be because your spouse died, this could be because you guys separated, actually got divorced.
So I think Amanda's frozen there. So anyway, the answer to your question, Michael, is 6 months. You can send it in 6 months early. Normally people do about 3, but you should go closer to 6 nowadays. And the answer is yes, you can renew without your lawyer if you want to. You don't have to have a lawyer if you don't want one. Now, so what was she talking about? Basically, it looks so funny with your face frozen there.
Oh,
there you go.
Okay. Sounds weird. Did you continue?
No, I was answering Michael's question, and then you came back, and I didn't want to miss where you were starting.
Okay. Did you finish answering Michael's question?
Yeah, 6 months, and yes, you don't need a lawyer.
So, so if you and your spouse are no longer together for any reason, you're encouraged to file immediately. You don't have to wait if it's before the 90-day period. If it's after even, you can file. We actually had one client that we filed about 2 months after she got her conditional green card because she was being subjected to abuse. So there's no requirement to wait that entire period. But if you're jointly filing, you have to. And if you're just joining us,
crazy one for you about changed circumstances and 751s.
Go ahead.
We had a client maybe like 10 years ago, and he had marriage through green card, filed a 751, was approved, filed for 751, was married, went to interview. After interview, they didn't have a decision for a couple of years. Apparently during that time, they got divorced. He was not our client at the time. We didn't file the 751. But he gets the 751 approved. In the mail, the approval comes. He lives in the United States for a whole bunch of more years. Files an N-400, and I think that's where we started. No, he filed the N-400, gets approved, goes to the naturalization ceremony. They arrested him. They arrested him because he didn't tell them that he had divorced from his wife after having attended the 751 interview, but before the permanent green card was approved. Is that interesting? So then they basically said there was a fraud misrepresentation, and then they said they were denying the 751. Wow. So they put him from going to his citizenship naturalization to jail. I got him out of jail, went to removal proceedings with him, filed a new 751 proving marriage was entered into good faith, but terminated due to divorce. And it was really hard because there was already that major hurdle to get over, the fact that he divorced his wife after the interview. So it sounds like they stayed together to get through the interview, because otherwise he'd have to file a waiver case. At that point, it's much harder. So basically, thank God he won. Now it's like, so many years later.
And we have a question here about the processing time. Actually, someone else asked me that question too. I don't know if it was you or not, but do you think it's beneficial or risky to file the N-400 while your I-751 is pending? This has come up a lot lately because yes, the processing time has
risky. No,
yeah. I was going to say
it's not risky.
It's not risk. So we
risk is not the right word.
We used to encourage people to wait because we don't like to confuse USCIS. You file one thing and then another thing. We don't like to confuse them. But it's not your only option. I'll first say that.
I would like to say one thing.
Go ahead.
I would imagine that you would at least want to wait till after your 751 interview, because your file is going to be with the 751 person, and then if you file an N-400, God forbid your file goes to that guy first somehow. Like, it won't make any sense.
No, because they grant them together at the interview.
In theory, but I'm just worried about where files go when they get moved around.
Well, that's why we've always been a little hesitant, because like I said, we don't like to.
I think you could.
You can do it.
But the reality is, no, you can't.
No, you're allowed to. It's like legally.
The reality is you need to file 3 months before the second year. Therefore, you're not eligible anywhere near naturalization. So you file, you get a year and 3 months before you're even possible. And you can't file at the 3 years. You could file at 3 years, you're married and still living together, right? So that's what she's thinking. I don't think it's beneficial to file right away. I think that. Well,
what he's saying is that
it's extremely rare that your situation would ever happen.
No, it's not. What are you talking about?
No, but then it would be a problem by the time the N-400 interview came, because those things take a long time too.
Aaron.
But I guess they make a decision.
The only reason you don't want to do it is because they get confused. But other than that, it can, if your application's been forgotten about because it's USCIS and it might go in the pile that they forget, that can help them remember. But there are other things you can do to get a decision on your I-751 first. It's not going to hurt you. It's not risky. If anything, if you do it, they end up combining it. And if they're not going to grant your I-751, they're not going to grant your naturalization. So you may have wasted money filing for naturalization. But other than that, it's not a risk. It's just ideally, nobody's getting them granted within a year these days. So everyone, if they're still married and living with their spouse, they're eligible for naturalization before.
Well, a year and 3 months.
But there are other things we can do, and we're going to get to that.
And then the interview is another year after.
We're going to get to what to do when your I-751 has been pending an ungodly amount of time in a little bit. But, that is definitely one of the options. So let's keep going here.
You can file your EID on your own, Michael. The regulation says 6 months. It's true.
Yeah, you can file.
We always generally do it about 3 months too, just because that's for some reason. I think it's what it says on the form, but the reg says, I'm reading, it says 6 months. So just file it on your own. Who cares? Worst comes to worst, to file it again.
So what happens if you file your I-751 late? Well, there is an exception, and that exception is you have to submit a written request to be excused for your late filing, and you have to prove that it wasn't your fault. And the standard that you have to prove is that there's been extraordinary circumstances that are outside of your control, and your delay in filing, the length of your delay was reasonable. One of the notable approvals live that I did this week, I talked about a case where the client filed 8 days late, and he got a request for evidence and had to explain it. And he wanted to say he was in the hospital, but the problem was when he got the medical records, it said he was in the hospital months before it was due, not when it was due. So I said, this isn't going to work. So it turned out he went to someone to get help filing. The guy said he was going to send it out on time and didn't. So we explained it, we were honest, and it got approved. But that was only 8 days. It's really not that easy to get it approved when you're filing it late if you don't have a good reason. Some examples that they give, that are acceptable reasons, and again, keep in mind, just like hospitalization is the first reason on this example on this list. You have to be hospitalized pretty much when it's due, and then kind of like get out of the hospital and get on top of it. You can't wait months. If you're sick in bed and you can't do things, then it's reasonable to have a longer delay. A long-term illness is another one, death of a family member, a legal or financial problem, if you're caring for someone, serious family emergency, work commitment, family member on active duty with U.S. military. So those or
the alternative, which is interesting. The alternative is a situation in which someone's filing a non-joint filing. So basically, if you file a non-joint filing, there's no time limitation. So you don't have to explain for timing issues at all. And if you get your filing in and it's based on one of those waiver reasons, abuse, divorce, I guess that's it,
Well, we'll get to that
then you don't have to explain for it, and the extension does qualify for the extension of the work and travel authorization while the 751 is pending.
But keep in mind, even if you and your spouse are no longer together, if you don't file the I-751, you're going to get put in removal proceedings.
Oh, yeah. You have to file before the proceedings in order for any of this to make any sense.
And we will talk about removal proceedings a little bit more.
But you'd file it in proceedings too.
Well, we'll talk about that a little bit more shortly. Now, you can't file it in proceedings. You file it with USCIS. But again, let's stick to the outline. And if you're just joining us, welcome. Please feel free to ask us any questions that you have. We are moving on now to what do I do if I'm no longer with my spouse? Aaron?
Thank you. This is like a layup. So if you're not with your spouse and you've already have a conditional permanent resident card, you file a 751 right away.
And
you get in trouble if you don't. And you tell them your change of address.
No, you don't file a joint waiver.
If you file jointly, then you're going to need to explain why you're not together anymore. You're going to have to change it over to a waiver case, abuse or divorce.
So there are three main types of waiver cases.
That's
one
like a
is
B+ answer. All right.
death
like
of the spouse or divorce.
No, death.
Extreme cruelty and battery, which is the abuse waiver. And then the last one, which I think is a lot rarer, is extreme hardship. So if you're filing based on one of these waiver requests, you do not need to have your spouse's signature. Your spouse is not involved at all at this point. If you've already filed your I-751 jointly and then your marriage breaks apart, you can switch to a waiver. If you're honest with USCIS that you're no longer together, you can still get it approved as a joint, but it's hard. Because lately they've been taking so long, it's not surprising some marriages aren't making it to the end, unfortunately. But basically, these are the three main waiver categories, and we'll talk about filing tips shortly about it. Because first I want to go into a little bit about best practices for joint filing. So I mentioned earlier that the purpose of the I-751 is to prove that you didn't marry your spouse just to get a green card. You married your spouse because you intend to share your life together, love each other, etc. So you should have a lot of evidence by the time you're filing the I-751. And not all evidence is created equal. So when our clients come to us, we give them a nice big checklist that contains all the types of evidence that we've submitted for clients over the years. It's a non-exhaustive list of what you can submit. And it has everything from if you have a birth certificate for children you have together, all the way down to at the least important evidence, which are photographs. So,
and everyone has problems with these documents, so don't get too scared if you don't. We work on it.
You ideally, once you guys get married, you want to start doing what you can do to join your finances. Put both names on bills and leases and things like that. There's no one right piece of evidence that's gonna seal the deal for you. The more you have, the better. And again, not all evidence is created equal. So you want to focus on joint financial evidence like joint tax returns, bank accounts that you use, not bank accounts that you open and you don't put money in or take out money, but bank accounts you use. Credit cards that you pay the bills, not credit cards you just rack up a bill and never pay it. Certain things, they look a little better than others. Even not all pictures are created equal. I tell people this all the time. They give me a stack of photos.
Oh, put dates on your pictures.
Well, you got to describe what's in the pictures.
I mean, like if you have that setting on your camera, put the date on it.
That's a good call.
Yeah.
I've actually had people take screenshots from like social media, like that it shows where they are, who they're with. Like that's
immigration's looking at that too.
Yes, your social media.
In this video.
your social media is not private, and the government can.
They will look.
They
Right
will
when you're
look
coming in
and
the door on the day of your interview.
I've actually heard a story. I don't remember who this was. That someone who was coming. I think they were a conditional
Coming in the
resident.
country.
They were entering the country, and the officer, the CBP officer, took his phone and saw him like sexting with a different
girl.
woman.
Yeah, that wasn't his wife. And then he told his wife.
And then they told his wife.
Yeah. And the wife came and got him.
Yeah.
Awesome.
So if you file as a lot of evidence, you actually have an opportunity to have your interview waived, because everybody.
I don't think so anymore. I think they're doing interviews on all the 751s.
No, I know that's what they said, but we've actually had a couple this year get approved without an interview.
Waiver ones.
No, I'm not talking about a waiver. I'm talking about joint. We've had some this year. Yeah. So the point is, you have to assume you're going to have an interview, and the only chance you have of getting that interview waived, especially today when they claim they're interviewing everybody, is you have to have a lot of marriage evidence and a lot of good marriage evidence. The more you have,
you're getting an interview.
Yeah. Are you keeping your eye on these comments? Hey, Tanya. Hey, Sherlyn.
Hey.
Hey, Lambert.
Yeah, Michael wants to do his EAD. I think he should. I think he should rock on and just do it. Balls to the wall, man.
If you're just joining us, if you have any questions, please feel free to ask. And now we'll go on to best practices for a self-petition. So we just mentioned that there are three main types of self-petitions or waivers of the joint filing requirement. Those are divorce or death. Divorce or death. Yes,
there was something else that you said, but you didn't finish. There's a waiver called an extreme hardship waiver.
I'm getting to that.
I got it.
Okay.
And I'm not reading off notes. This is just memory. The extreme hardship waiver can be a hardship to anybody. That's the interesting part. It doesn't necessarily have to be to you. It could be to your kids.
You know what I also found out today? Because I was doing, I always research before I do these. I didn't tell you. So I figured it's better I told you now.
Okay.
Somebody once got it approved based on, there's like a USCIS decision based on extreme hardship to a community, because this person was a doctor in an underserved area.
I like it.
Yeah, really good.
That. Yeah, I dispute that kind of bullshit. I like that.
We got another question. If an interview for I-751 is required,
it's like an I-130 interview.
It is similar. It's similar to in New York. There's two types of interviews.
It's not a Stokes.
It's not a Stokes. So it's like the Stokes interviews where they split you up. It's like the first one where you're together, and it's the same thing. They're going to ask you. They're much tougher actually. The I-751 interviews, because they don't think there's any excuse for you not to know things about your spouse this time around. You've been married now for over 2 years. By the time the interview,
right, you should know what it says on
3.5 years. So they do have a higher expectation there, but it's going to be the same type of thing. Less security questions. If you have any criminal history that didn't exist before your I-7 or before your green card interview, that will come up as well. That should be expected, but essentially the same. We prepare our clients the same way for that interview that we do for their first marriage interview.
Yeah, we do a practice. I pretend to be the officer.
Yeah.
And I'm very tough.
For
I'd be a very tough officer.
I know.
Mean judge.
One thing to keep in mind about all of these waiver I-751s is that they're discretionary. So even if you prove that you entered your marriage in good faith and you got divorced or that you were abused, they can still deny it. They can deny it. They would deny it because there's some type of good moral character issue or criminal history, but it's not an automatic. So that's one thing to remember. The second tip is that, and I mentioned this earlier, if you can qualify for more than one ground of waiver, you file it on more than one ground of waiver. You can also switch grounds. So if you are filing based on abuse because you were abused, and then you started a divorce and now your divorce is final,
you send them a copy.
You can then send them a copy and ask them to switch.
And you change over the type of filing. Very important.
Yes. If your divorce is not final when you file your I-751 waiver, you're going to get a request for evidence. And you're only going to have 87 days from the day you get that request for evidence to give them a final divorce.
So don't do your divorce in Bronx.
Yeah. If you do not do,
587 days.
It's going to get denied. You will be able to renew it before the
immigration proceedings. You'll be waiting on your divorce. It'll never happen.
So, and depending, I don't know anywhere where a divorce takes like a couple of weeks only. In New York, for sure, it doesn't. Especially a contested divorce, if there are kids and stuff, it could take years. So
there's some way you can do it, rapid divorce. There's some expediting requests you can possibly do. I heard about that. Anyway, we'll do another video on that.
Either way, if you have another ground, you want to file it based on that too. And keep in mind, though, if you did file a waiver ground on the divorce ground and your divorce isn't final, it better be final soon, or you might have a problem.
Yeah.
For the extreme cruelty and battery waiver ground, if you are missing certain evidence that a normal couple or relationship would have, you explain it well why you're missing things, you're going to be okay. It's actually very similar to how we do our filings for VAWAs, which stands for Violence Against Women Act, for people to get their initial green card. It's for abused spouses, children, and parents of U.S. citizens and permanent residents. And essentially, like there's a lot of patterns that you see with victims of abuse in immigration. And one of those things is that the person who's not the immigrant wants to control the relationship by not opening the joint bank account and not putting your name on the lease, and doing things like that, so that you're dependent on him or her. So we see a lot of times that people come to us and say, I don't have that much evidence of the marriage. What am I going to do? And it's not ideal, of course. It's better if your names are on things, but that's actually part of the abuse. So it's all about explaining what happened and clearly explaining, like, look, I've had people tell me so many times, like my husband, my wife, they kept promising me, we're going to go to the bank and open the joint account. And then they'd get mad at me and say, see, you didn't do this, so I'm not doing it. And they were just lying the whole time. And they didn't want to put me on the health insurance because they didn't want me to be able to get myself looked at or something, like when I'm sick. I mean, unfortunately, it's common. But the good news is that you don't have to worry that you're SOL or you're in a bad spot and you can't get out of it just because you're missing some evidence. We sit down with you and take the time to really explain why you don't have these things, and we never have a problem with that. Another thing that you should do, regardless if it's a psychological, physical abuse and whatnot, is go to counseling for two reasons. Number one, it will help you. Will help you psychologically, because domestic abuse is very traumatic and it's very hard to deal with. And it's something that people feel really alone, isolated, and you need professional help. And that's the first thing we say to all of our clients. Do you have a therapist? Do you need help finding, some type of counseling service? The second reason is it gives us some evidence for our abuse waiver, because we always get some type of letter from the therapist in order to show that, back up your claim that you're a victim of abuse. So it's highly recommended that our clients do it. And we often send them to places like Safe Horizon, which is a nonprofit organization that helps women and men who are victims of abuse. So if anyone watching out there, if you need any help with that, please reach out to us. We'll be more than happy to point you in the right direction. And the other things that you can also submit are things like court documents. So if you filed a restraining order.
Police reports.
Orders
of protection.
Yep. But remember, you're not
medical records, ambulance records.
You're not required to call the police. You're not required to go to the doctor. We recommend.
We need evidence.
If your life is in serious danger or imminent risk of serious physical injury. But in terms of immigration, if you don't have that stuff, you can still get your abuse waiver granted. And that's what's most important here.
It's possible.
What's that?
It's It's possible, but evidence is important.
But
Evidence
and
is
that's,
okay.
I had so many people come in and say, like, we always go through the list. Did you do this? Did you do that? You call the cops. Did you, file for a restraining order? And I've had so many clients say to me, I'm too scared to do this. I'm too scared to do that. And, luckily I can tell them it's okay. It's not the end of the world. We can still help you. Here's what we have to do. And it usually starts with counseling again for those two reasons I just mentioned. It's very beneficial. The third and final waiver ground is extreme hardship. Aaron, you were itching to talk about extreme hardship.
Moment has passed. It's yours.
Moment passed. Well, if you caught our live on cancellation of removal or inadmissibility and waivers, we talked about extreme hardship. It's the same thing here. The only difference is, as we mentioned a little while ago, that the extreme hardship does not have to be to a specific person. In fact, I've learned now it can be to a community, but
Can't be to a thing.
To a thing. But you do have to prove that it's above and beyond what the average person, community, entity, whatever it is, will suffer if you were to have your conditional residence terminated.
What if we could use a pet? No, pets could go with.
Maybe. Well, but that's the point. It's open-ended. And this is the only waiver ground where you don't have to prove a good faith marriage. It doesn't mean that if you have a fraudulent marriage, it's going to be super easy to get approved, because remember, it's discretionary, and they definitely will look at that, and it's still recommended to show that you had a real marriage, but it's not a statutory requirement. And again, if you're just joining us, if you've been watching, don't be shy. We're here to answer your questions, so feel free to do so. Have you been keeping your eye on the emails, Aaron, too? See if we have any questions? Oh, no. I have. Don't worry.
Can you check my email?
Okay. We're now up to
your email.
Oh, I didn't click through these. I forgot I did this. Denial reasons. Aaron, why do I-751s get denied?
Because the marriages are fake.
That is one reason. Do you is
there another one?
Not filing on time.
There's that. But I don't think we've ever actually had one of those and then we've not been able to get around it.
Untimely filing?
Yeah. I can't think of anyone who actually got really just stuck and screwed and had to leave forever because they didn't file on time.
I can't remember it, but
usually it's about the marriage discretion. It can be criminal issues.
Criminal issues, yeah.
Anything that's going to pop up and violate your green card that they see, because remember, whenever they're looking is when you're going to have a problem, right? So,
So if your I-751 gets denied, what ends up happening is you will, along with your denial, will come a notice to appear in immigration court, and you will be subject to removal. Some people know it as deportation proceedings. And what is important to know is a couple of things. Number one, you do have an opportunity to have your denial reviewed by an immigration judge. You'll be able to present more evidence. Instead of going to USCIS and having the officer ask you questions, your attorney will be asking you questions, as well as the government attorney and the judge. It'll be essentially a trial. You cannot leave the country. You still are considered a conditional resident, so you can still work in the U.S.
Yeah, you can't travel because you're in proceedings, but it's not because you're not a conditional resident.
If you leave the country while you're in proceedings, you will be deporting yourself. So do not do that. However, if you had a joint I-751 denied, and now you're no longer with your spouse, you cannot file a waiver I-751 with the judge. The judge doesn't have jurisdiction until USCIS denies it. So what you have to do is file with USCIS, go to court, and ask them to put your case on hold. And they have to put. We actually had one case.
They used to terminate your case.
They
before a Supreme Leader became president.
No, they
had 751 cases of pending 751s. They would send them back. They terminate it, let USCIS adjudicate the 751. They would terminate it without prejudice. That's all. So basically, if the 751 wasn't approved, the officer would send you right back to the same judge.
Oh, and I did want to say
Or
one
you get
other
reserved, I guess, with a new NTA. But we had that case too. They didn't get reserved with a new NTA.
If
That's
you,
another video.
If you fail to file your I-751 on time, and you're still married and living with your spouse, you actually can file for adjustment of status again. Yeah, I read about this today too.
Oh, you'd actually have to file for adjustment of status again.
Well, because you lost your, instead
we
of,
talked about this a million times.
Yeah.
Yeah.
But so, yeah, you can refile for adjustment of status.
Because you don't have a green card.
Because you don't have a green card.
That's simple.
Your adjustment of status means you're adjusting status from a non-immigrant to an immigrant. And if you're already an immigrant, which is what you are when you're a permanent resident, you can't adjust to an immigrant. So your status is terminated. You're now back to whatever immigration status you were before.
Which actually, no, you're not. You're not back to that status. You're just back to that as your most recent entry and admission for adjustment.
You remember the 237A1H.
Because your last admission is when you adjust the first time. How would you possibly? How does that work?
It is allowed, but it's like I think you have to refile your I-130.
Yeah, normally if a 751 is denied, you just refile another 751.
Right, unless the only real exception is if you forgot to file and you're still with your spouse and your relationship is fine, then you're not going to get excused.
And then you'll get a full green card right off the bat.
Then you'll not have to deal with an I-751. That's correct.
Yeah,
if you get your green card,
you'll
already be married.
It'll be quicker than doing 751. That's the crazy.
Another thing to keep in mind is that when you're in removal proceedings, the burden is on the government, not on you, to prove by preponderance of the evidence, which means like 51%, that your I-751 was properly denied. So when you file the I-751, it's your burden to show that you have a real marriage. But once it's denied, the burden is now on the government to show that USCIS made the right decision. And you will be given another opportunity to submit additional evidence. If you need to file a waiver request, your proceedings will be delayed because USCIS has to decide that first. If USCIS grants your I-751 while you're in removal proceedings, you're not automatically out of removal proceedings. We have to then file a motion to terminate your removal proceedings before that will happen.
Yeah, they used to do it if you had a 751 pending.
Sometimes. Yeah, well, no, they used to admin close those, I thought.
No, an admin closure is still in proceedings so that the officer can't do it.
Yeah, I mean, it is limited.
Terminate it without prejudice.
When you're in removal proceedings, it is limiting because, you can't leave the country. Thank you, Lambert.
You should put that on a business card. That's the law.
Okay.
Actually, remember I got in trouble with the Bar Association that time about 15 years ago. Not real trouble, but on the website, my old boss wrote that I was excellent. And apparently they had a random review, and you can't put that you're an excellent lawyer. You can't be better than competent. I said, okay. So I tore off the quote from the website.
But you can leave reviews and have those reviews on the website. So none of that makes sense.
No, we can't.
Yeah.
No, the conclusion was I couldn't put somebody's extreme compliment to saying I was it said like you're a brilliant genius or something like that. I couldn't put that on there because it's not objectively true, and I was not allowed to set myself higher than any competent attorney. That's what they said.
You can't take a quote from someone. That you can put direct reviews that say that.
No. Well, I just asked her to write a review for the website.
Yeah, that's what I'm saying. Yeah. Anyways,
very nice.
So if my I-751 is taking too long, I have so many conversations about this that I could recite this in my sleep about what the steps are that you have to take. So I will share them with you today. Now, first of all, when you say taking too long, you have to put that in perspective. Now, there is a law that says that, I know, and this will surprise anyone who's waiting right now for a decision, that USCIS has 90 days from the day you file to either give you an interview or waive the interview requirement and make a decision.
Isn't that crazy?
If they don't waive the interview, then once you go to your interview, the law says they have 90 days from that time to make a decision.
It's supposed to be 6 months.
anybody sitting there who has one of those extension notices that says 18 months is probably laughing because
Crying.
I don't know. Maybe before my time, maybe before I was a lawyer, they made these decisions in 90 days. But that is not where we look at reasonableness. That's our baseline. But we have to look at processing times that's listed on the USCIS website, as well as general what's going on, like with COVID, processing times aren't accurate at all.
And also, basically, the reason that they say they have all these delays is for security measures, so they can check your background, and they have no limits on times for that kind of stuff. So
that's not true. That's not
well,
true.
they have to be doing it, right?
So let's say you're in a position where your I-751 extension notice is about to expire, that you've been waiting now for over a year and a half, almost now it's 2 years.
And that's not unheard of now.
It's not unheard of, but it is unreasonable. So what you have to do is there are lots of different steps you have to take. Now, someone asked us earlier about, should I file an N-400 because I'm already eligible for naturalization? That is one thing you can do, because that it could potentially take your case file from the forgotten pile to the not forgotten pile. But there's another path you can take. And that's the path of exhausting your administrative remedies. And what that means, you're going to have to file a case status request with USCIS. So you're either calling that 800 number, asking them what's going on, filing case status request online, and then waiting forever for them to respond to say your application is being processed. Thanks. You have to record the date of every call. You get an ID number when you call. Same thing with when you submit the case status online. Once you've submitted a few case statuses and they've responded saying that they're working on it and you still have no decision, the next step is called an ombudsman request. And that's where it kind of goes to this other part of USCIS that's like their supervisory agency that that takes all your complaints, and you tell them, hey, this is taking too long. Why is this taking too long? And they're supposed to respond to you in 60 days or 90 days, and they don't do that anymore. It takes forever. And they get in contact with USCIS to find out what's happening, and I don't know if they do anything, to be honest. Every time they respond to one of mine, they just say, it's pending. I don't know that I see a question, but I'm not sure.
Yeah, she's asking how long the processing time is for a T visa.
Oh.
What's the form number? I'll tell you right now. I've got the processing time.
It take a long time.
Yeah.
So when your ombudsman,
hold on, I'll tell you what it says.
Your ombudsman request fails to do anything, the next step is contacting your congressman or woman. We've had some success contacting congressmen. Depends who it is, how willing they are to help. But they have each congressman in their office has a special congressional liaison person to USCIS that contacts USCIS for you to find out what's going on. So it certainly can help in some situations. And we've had mixed results with that. Again, it just depends on where you live, who your congressman is. And then the ultimate last option is called a writ of mandamus. And
it's the one that actually works fast.
Yes.
You should do it. I like it.
So what a writ of mandamus is essentially you're suing the federal government.
Everyone in the government.
Anyone who has anything to do with your application. So I think I just submitted one that had 9 defendants. It was USCIS as an agency, the acting director of USCIS, Department of Homeland Security as an agency, the acting director, secretary of DHS, the FBI, the director of the FBI, the attorney general.
You get the president in there?
No.
Oh, he's immune.
And it was also because it was a waiver case based on abuse. Also, the Vermont Service Center director.
Yeah.
So essentially, you're suing them, saying you are taking too long to make this decision. You have a duty under the law to make a decision, and we file this complaint in the district court, in federal district court. We have to then serve it on all these parties, and then they have 60 days to respond. Either so, like one of three things will happen in that 60 days. One, all of a sudden, something's going to happen on your application. We did one recently.
A week and a half later, she has an
A week
interview.
and a half later, our
Magic.
client has an interview after 3 years of silence. So that.
Amanda, you're frozen again. So anyway, and well, she figures out whatever that is. T visas right now are taking between, it says on their thing, 18 to 27 months. The reality is it takes as long as they need to take. 360s are pretty similar to that.
We're back.
For the I-360s, it's also similar to the 18 to 27 month range. That's what's posted. So during that time, you'd be able to apply for a work permit and stuff like that, but you would have to wait, a couple of years. But if you have questions, call us about it. Unfortunately, neither of us speak Spanish. Most of our clients are French speaking, actually, or English speaking, but.
So I'm saying what the government will do in response to a written mandamus. The first thing I said is the ideal, that they're just going to do something and that's it. They do something on your application, you get a decision, and it doesn't mean they're going to deny it. Actually, it means they're going to make a decision. If that doesn't
to bring the body, I think is what it means, to show the body. They need to come.
Habeas corpus.
Oh, what's a mandamus? To bring it, make a decision or make an order. What's mandamus mean?
To act.
Yeah, do an act. Like it's the same thing. It's like do the thing.
So like I said, there's three things that can happen. Either that, number two is a motion to dismiss. That's going to happen if the filing is incorrect in some way, like you file it in the wrong court, or you don't name a party that should be a party. That's why we had all those people, those 9 defendants, just because we knew that we were told it was held up for security checks, so you had to include the FBI, but we didn't want to leave out any parties because we wanted. Yeah,
because then the judge will make us do that.
Yes. Writ of mandamus, they're not exclusive to I-751s. They're the last resort tool for any
government act.
Yeah, any government act.
Word. Like it's ordering them to act.
So it's not every benefit in an immigration has something in the law that gives a time limit. Like I mentioned, the 90 days with the 751s. Naturalization, they have 90 days after your interview to make a decision. And technically, you can sue them to make a decision after that. But again, there are certain times there are requirements that you go through those steps I listed before you file the writ of mandamus. Even if those steps aren't required, it's highly recommended that, because the court doesn't want you just, filing lawsuits all the time in federal court. It takes up a lot of time for these courts to go through these cases. So they want to see, look, you really made an effort to resolve this with the agency, and they just ignored you, basically.
Which is what happens to a lot of people.
So a motion to dismiss is a possibility, and that's annoying. Or they can answer. They can answer your complaint and say that either that, I don't know what they would say in an answer, honestly. I think you're mostly looking at
deny.
Well, they can deny all they want, but if they don't have a duty to act, they're going to file the motion to dismiss.
The lawyer's going to call the 751 people and be like, "What the hell are you doing?" I imagine.
So
process this thing.
The writ of mandamus, it's an interesting remedy, because if you do end up, if they answer your case and it continues and you end up getting an order from the court in your favor, you can actually also get them to pay your attorney's fees, which is they should, because the only reason you have to pay an attorney to do that is because they didn't do their job. However, just so you know, the likelihood of it getting that far is slim, because most likely
if you're suing the government, you're paying something for it.
Yeah, they're not even going to bother answering you. They're just going to go ahead and make a decision. And I know
And that's the tactic. That's the point.
That's the point of it. And I've been asked before that, like, are they just going to deny it because they're pissed you sued them? No, there's no risk of that.
They're not pissed you sued them. Don't worry. You know,
And,
it's like returning something home.
There's review, like different way, like checks on their decision. So like if they did deny it, you'd be in removal proceedings, which is not ideal, but you get the judge to be able to review it and make a decision. You know, you say to the judge, look, this is they only denied it because I sued them. It's
and
be
showing that you sued them really shows you got a lot. You know, there's a real pair there. It's not some fake case. It's a real thing.
Right. And that's the other thing. You're not going to want to sue them if you don't. Yeah. If you're not going to get approved. Why are you rushing to get a denial? That doesn't happen. So we've never been in a situation where clients have approached us to do it where they their case was shaky. We haven't had that.
Usually I get in touch with them. We start writing them letters. We start doing everything. And, you know, things process so long.
I've actually, before I filed it, I emailed it over to the director of USCIS and the director of Vermont Service Center and gave them 14 days.
Oh, yeah. I was like, why don't you just email them? Send them a demand letter like any other litigation.
Yeah. I mean, I've heard it's worked before. It depends, you know, you never know.
I figured the judge would be pissed if you don't give him a demand like any other case.
And it's not even that. It's just like I don't know if anyone out there, if you filed things online in federal court, but it is not made simple. Put it that way. It took me like an entire day to file something online. I was losing my mind. I had to call
each document.
Yeah, they have like all these limits on file size. You have to have it right. It's a nightmare. So if you can get it decided before then, that's why we say writ of mandamus. They're expensive.
It's the last resort.
They're time consuming, and you only do it if everything else has failed.
Because immigration is administrative. Remember that. Immigration is administrative law. You're supposed to be working with the administration that is set forth by Congress. That's what immigration is. So you're supposed to deal with them. The only time you're allowed to go above them to the judiciary is when the administration's not doing its job.
Now, one other thing I really wanted to just put out there so everyone knows is we talked about a little bit about naturalization, that if you once you're a permanent resident for 3 years, if you're still married and living with your spouse, you can apply for naturalization. That same rule applies if you filed based on a waiver ground based on abuse.
Yeah, you get the 3 years.
So you actually don't have to wait the full 5 years if your 751 is granted based on that abuse waiver, which is nice to know too, because there are people out there that want to stay in a relationship simply because they want to be able to file for naturalization sooner, and that's exactly why Congress made that rule, because you should not have to stay in a relationship with somebody who's abusing you. Nobody should. So you don't have to even take that into consideration. You'll still be eligible. So that's another thing to keep in mind. But yeah, does anyone have any other questions about this? We got a few more minutes left. We could talk about some of our favorite cases. Aaron, you talked about one earlier. Then we actually did have a case where an I-751 was approved, where they jointly filed and then they got divorced before the I-751 was decided, and they didn't tell USCIS, and it was approved. We had a case like that. I'll tell you who it is after.
I think USCIS made a mistake.
What?
I think that's a very interesting point, because that's the opposite of what happened in the other case that was extremely litigated.
And we told that client, like, we didn't even know. When this client told us, we were like, you better not.
That's how the other guy got caught. Did he naturalize yet?
No, he hasn't. We told him not to.
When you get caught.
Yeah, we told him not to, because he's going to get caught.
That's the same exact thing.
You have to show the divorce at the naturalization.
Yeah, and when they see the date of the divorce is like before they gave you your green card.
Now, and in his case, I remember it was pending for 4 or 5 years. They had there was so much that went on the 751 that if they were just upfront with USCIS, they did have a real marriage. It just didn't work out.
They could just file a waiver.
No, he don't. That's what I'm saying. This is one of those cases that he wouldn't have needed a waiver. He would have just been able to say, "Look, this is a real marriage. You guys took forever, and that puts a lot of stress on a marriage, you know." So
Does it?
I mean, I
Does it? Or is it just
imagine. I would imagine.
I give people a very hard time because I don't like processing cases for marriages that aren't good. I don't want to deal with any fakes.
Yeah, so
I'm a little rough on people. It's good.
When people file for naturalization, a lot of times that's how like a lot of fraud gets caught. We've dealt with that a bunch of times. So yeah, we will probably do a naturalization live Q&A maybe sometime soon. We haven't decided our next topic. We're open to suggestions. But I encourage you guys, any more questions before we get going here, we're happy to answer. Don't forget to follow us, like us on Facebook, YouTube, Instagram, Twitter, all those places. We're there. So you don't miss any of our lives. And if you need an attorney, we're here for you. As I said, contact information's been scrolling across your screen all day. Give us a call, send us an email, and we will be more than happy to help you. And if we can't help you, we will tell you honestly we can't help you. But if there's any way,
well, if it's a 751 issue, we're gonna figure it out.
Yes, I mean we're very good at what we do. We know how to do these things, to present it to immigration so that they see things the right way and understand it the right way, because not every relationship is the same. Not every situation. We've had clients that lived in separate states get approved that were married.
We got a green card for a husband and wife. Wife's down in Florida, husband's up here working, and we were honest about it.
That was real quick too. But it's all about, like I always say, that we're basically storytellers. We take what your actual facts are and what evidence you have, and we present it in a way that tells your story to immigration and shows them, look, this is look how happy they are. Look at their relationship. Thank you, Jessica Shapiro. No relation.
She's not a paid spokesperson.
But and if you like this banter between Aaron and I, you could just stop.
Anybody here? I need a haircut, Amanda. Jesus, this Corona thing's killing me. And I just got a haircut. It's like a bush. All right. Good night, everybody.
That's lovely. Well, thank you all for joining us. We'll be back again in a few weeks. Send us your topic ideas if you have anything you want to talk about. And again, if you need us, we're here for you. We're more than happy to help. We appreciate you all watching today. Have a fantastic night and stay safe out there.
Thanks, Amanda.